the other small items. That hardly ever happens. They wait till court orders. They don't do that much, whatever. They don't know they should be doing something. You can't find them, whatever. So this man has done something. Now, did he do it precisely perfect? No. Did you come right away so you could get, if she's what, 12 and 10 now, or if I forgot what you said, 10?
10.
Then you could have had 10 years of child support if you brought the case as a baby, but you didn't. So you already gave up a bunch and you were doing a loan. I get that. But he did step up and has stepped in and has given at least $12,000. So you got to give him some credit for that.
That's what I'm saying. Like, if we just can get this done, let's just stop all of this. No more back paying. Let's just move forward. I just want to get this done.
Ma'am, I can finish in the next 5 minutes one way or the other, but I can't believe that after all this, you're saying now I want nothing. Let's just start scratch for fresh. But you can say that if you want, but I'm not trying to pressure you into anything. I'm trying to get the facts. I'm barely just now getting the facts. It looks like the facts are that if he paid this much and we had known and we had been there and done the math and he had known, that maybe he owes you $69.45. Mr. Garza, let me hear you respond. Why or why not shouldn't you be paying something, given that you didn't pay the whole 4 years, you didn't pay anywhere near for 10 years, but there's still maybe something owed here, even though you did pay up to $12,000. What's your position on cause number 24-3166-DCD? Present in my virtual courtroom are both parents. That would be the non-custodial parent Rene Garza and the custodial parent Angelica Cano. Let me start with Mr. Garza. Go ahead and announce yourself with your full legal name, sir.
My name is Rene D. Garza.
Thank you. And same for you, Ms. Cano.
Angelica Marie Cano.
Thank you. Now I need to swear you both in. If you'd both raise your right hands for me. Do you each swear to tell the truth, the whole truth, and nothing but the truth? Starting with Mr. Garza,
I do.
followed by Ms. Cano.
I do.
Thank you. I need to tell you a couple things before I involve Ms. Nichols and we start talking about the actual case. Is that one, I'm an associate judge. I've been appointed to hear cases filed by the Office of the Attorney General, their child support unit. As an associate court, we are courts of record. They do not assign court reporters to our courts. We have a digital recorder. So be aware of that. Make you aware so that you'll understand all your answers need to be verbal, obviously, but loud enough for the recorder to pick up and the court to hear. No answering questions by shaking your head or nodding. That does not record. And no ahas or ahs. This is a formal courtroom, so I'll expect yeses and nos. The other part of the being an associate court is that you are allowed to appeal any rulings from this court to a higher court. That would be to an elected district judge. So at the end of the hearing, if you need me to give you more specifics, I will, but there is a right of appeal from this court to a higher court at the district court level. The second part of the recording issues is you did hear me announce that we were live streaming on YouTube. It is a requirement that the courts are open to the public. That's been true for forever. And courts had been sitting in courtrooms with people coming in to observe proceedings, whether they were involved in cases or not. They could watch their courts at work. It's a part of our Constitution, the open courts requirement. When COVID happened, they went to Zoom court as a way to just keep conducting business. They figured out because of the open courts, they set up the live streaming on YouTube as a way for the public to log into the YouTube app and watch the courts on a live stream channel on YouTube. So that's what's happening now. I tell you that so that you're aware of it and you don't blurt out your home addresses, your social security numbers, your cell numbers, something that identifies you that you probably would not want out on the internet for anybody to use it or abuse it. So I try to catch you if you get there, but if I don't and you say it, it's out there, I can't bring it back. So I'll take it back. So be aware of that. And also be nice so that people are watching this. And you're in a courtroom, people could watch in a courtroom anyway. So just behave yourselves. So the last part of the recording issues is do not record. It would be considered in violation of our laws, subject to contempt of court, punishable by a fine and or a jail sentence. So do not record. That applies to everybody here in the courtroom or anyone outside observing in. If you need to go on appeal, if you need it for your record for some reason, if you need a copy, you ask, there's a way to contact my court coordinator to ask for that. But otherwise, do not record yourself. Out of all of the recording issues, Mr. Garza, do you have any questions or concerns about any of them?
No, I do not, Your Honor.
And out of the for Zoom being going forward on Zoom, do you consent to do that, sir?
I am, yes.
Okay. Same for you, Ms. Cano. Any concerns about recordings?
No, ma'am.
And you consent to go forward on Zoom?
Yes, ma'am.
Thank you. Let me defer to Ms. Nichols next. She's going to identify herself and give me an opening statement on what I'm doing today on y'all's case, and then it's going to be followed by testimony. Ms. Nichols?
Yes, A.H. Nichols representing the state. This suit is based on a petition to establish the parent-child relationship filed by the OAG's office. DNA testing was done. It was completed, confirming Mr. Garza is the father of the child, and I've sent the DNA results to the court if you'd like to look at that.
They'll also be attached to the order, and if you'll ask me to admit them, I'll take judicial notice of them during the case. Okay.
Parties have agreements on every issue except for retroactive child support. So I'll tell the court what the parties' agreements are. Parties agree that the child's last name will remain as Cano. Parties are appointed joint managing conservators. The only change to that is that Ms. Cano will have the exclusive right to apply for the child's passport. Parties agree to that. Parties agree to standard possession schedule.
Okay.
Parties agree to each download app close and communicate through app close regarding the child. Parties agree that Mr. Garza's gross monthly resources are $5,000.67 a month. Mr. Garza has one other child for whom he pays child support. Parties agree that the child in this case will stay on Ms. Cano's health insurance and dental insurance. The cost of the health insurance is $235 monthly. The cost of the dental is $5 monthly. And Mr. Garza will reimburse mom for both the health and dental premium. Parties agree that child support will be guideline.
The state steps in and confirms the heart of the case, paternity. DNA testing proves the father beyond doubt, and the results are admitted without objection. Agreements are laid out one by one.
After giving credit to Mr. Garza for taxes and for payments on health and dental premiums, his guideline and the fact that he has one other child, his guideline support is $691. The parties agree on that.
Start dates, did you agree on those?
So the parties agree to actually start April 1st, 2025.
Okay.
And parties agree that Mr. Garza will pay court costs as billed 1 year from today.
And on the issue of non-disclosure, were you ever headed there or not headed there?
Oh, no non-disclosure.
No non-disclosure. So strictly on the issue of retroactive support is what you're.
That is correct.
Okay, if you'll elicit testimony, and the state's going to call each of you as a witness one at a time. I don't know who they call first; they get to decide. However, the other person, if you're not a witness, don't talk, don't interrupt. But you're going to have your turns to reply, just not on the other person's time, unless it's a valid legal objection, something that you could raise. Fine, but not just to interrupt and tell your side. You'll get that courtesy, and the same courtesy of not being interrupted when it's your turn. So, Ms. Nichols, you may call your first witness.
Yes. I will call, first, I ask the court to admit State's Exhibit 1, which is that DNA test result paper.
And Ms. Gano, you've seen that report?
Yes, ma'am.
And Mr. Gano, you've seen it as well? The DNA report that shows paternity of 99 point blah, blah, blah percent, 99.
I've seen it, yes. Mr. Garza, yes, I've seen it.
Oh, I'm sorry. I'm
That's
not
okay.
sure. Sorry, Mr. Garza. Yes, I just want to make sure you've seen it before I admit it. If you've seen it, then surely there's no objection. I will admit the DNA results, the report for the child. And then you didn't say it, but I'm going to presume it. This order will establish paternity as well. That's the whole point of this. But
That's correct.
and Mr. Garza will be found to be the father. Will be legal, being in the order. Okay.
I do have one question.
Okay, may as well ask it. What is it, Mr. Garza?
Back to the Cano. I mean, I don't know if we can get a chance to Garza.
Okay.
I can elicit testimony from the parties about that.
Okay.
Okay. And can you give me the birth date of the child, Ms. Nichols, so I can be thinking about it, all of this stuff while we're talking?
Yes. Let me give you the birth date of the child. Yes, her name is Ava Ray Cano. And the birthday is January 22nd, 2015.
So the child is
10 years old.
10 years old. That's right. Okay, thank you. Then we'll
Okay.
proceed with witnesses. Okay.
Okay, the state calls Ms. Cano. Ms. Cano, your child's last name is currently Cano, right?
Yes, ma'am.
Do you have any problems with the name being Cano-Garza?
No.
Okay. Pass a witness just on that issue, Judge, and then Mr. Garza, call Mr. Rene Garza.
Yes.
Sir, would you have any issue with your daughter's last name being Cano-Garza?
I do not.
Okay, so that's okay with both parties.
I'm fine with that. Yes.
Yes.
Okay.
That
Alright.
sounds like a good compromise. Thank you for saving me the trouble. Being one of you unhappy, but it still requires, even with a court order signed by me that says the child's name is changed, you really need to go to the Bureau of Health Statistics, amend the birth certificate. There's a cost. You can't rely on the AG to do that. They don't pay for that. And then there'll be a name change on there. And with that, and a court order, you can go to Social Security, you can go to everywhere and anywhere and prove the new name and show it so the records will be changed. And don't wait, don't prolong it, because then she's known as one thing and legally it's another. Then there's going to be huge problems for her down the road. So don't do that.
Who's responsible for paying for that?
I don't tell anybody they're responsible because either of you could do it. If you go down there together and split the cost, that's one thing. If you don't get along and one of you decides you can't afford it and the other one doesn't do it, you're in trouble. Or you're not in trouble. It's just it doesn't happen and then you can't do what you need to do. And what the child needs for later on for certificates of graduation, for all sorts of stuff. You really need to go do it. You decide and somebody beats the other one, let them know so you're not both there trying to do the same thing on different days and you confuse the staff people. And the state's not doing it. I'm just telling you that. So y'all decide. But thank you for the name change agreement. So Ms. Nichols, you want to continue?
Okay, I will now call Ms. Cano. Okay, Ms. Cano, were you and Mr. Garza living together?
No, ma'am.
And Mr. Garza, will you mute yourself? I'm hearing some fuzziness. Okay. I think just give me 1 second.
Well, I want to see how much is at stake, whether we're talking about $20,000, $10,000 or something else. And yes, that's big and that is meaningful. And if you want to go forward, both of you agree to go forward on sketchy evidence, I can do it. I do it all the time with pro se's, he said, she said. But again, you don't know how it's going to turn out. And if I make you come back, everybody will be unhappy, including me. But I might have better evidence for your particular case. I only
Right.
get what you give me, so y'all think about that. Ms. Nichols.
Right. Let me give you a number. It would be. Give me 1 moment.
You're gonna have to break it down for me anyway. So you want to tell me what you're doing and do it for me on the record?
Yes. So what I've done is from December 2020 up through May 2023, I calculated support at minimum wage. So that was for Mr. Garza, that was $203 a month. I've also
How
just
many months is that? How many months is that? 1 month,
that is
20 plus 12 in 2021, plus 12 in 2022, and 5 in 2023. Is that what you did?
The custodial parent explains years of payments through apps, deposits, food money, sports gear, and small but frequent transfers.
That's
yes.
30 months.
I have 29 months.
December 2020 is 1 month, 12 months in 2021, 12 months in 2022, and you said 5 months in 2023?
No, it was 4 months.
No. Okay.
Oh, I'm sorry. Yeah.
Well, no,
I would
5
have done
and
it.
5.
Sorry. Yeah, that's correct. Okay, we can do 30 since it was through May, so that's fine.
So 203 times 30 months. What
Okay.
you should have paid under minimum wage rate if I go that route would be what?
So that is $6,090.
Okay. So that
And
covers
then,
what's left for the
So
retro time
it's-
period.
so then it's June 2023 through December 2023. And it sounds like Mr. Garza is not really sure what his wages were then, so we can also go with minimum wage at that time. 203 times 7. That's $1,421. And then we know what his wages were for 2024 since we have a tax return.
Did
So
you the child support?
yes, so wages based on what he was making. It would be $787 a month times 12 months. And that is $9,444.
787 times 12. 9444. Okay.
Um,
And that's for 2024. So what's left in 2025?
and so now we would do January, February, and March of 2025 at Mr. Garza's new Raver's job. And that amount is
691?
$733 times 3.
Oh, you didn't include the insurance, I guess?
No,
Yeah.
he has one child.
I'm sorry, what?
He has one other child. That's why this is the multifamily calculation.
Okay, and what was the monthly amount number? 7 what?
733.
But it's gonna go down to 691, so that also gives credit for or it takes away the insurance credit.
Yes,
I'll
it
do that.
does. Unless of course the court orders retroactive medical and dental, but without credit for that, the number that I have is in total. Give me one moment, please.
19,154 or no?
$19,154, and then minus the $12,209. So the minimum the state would be asking, the minimum the state would be asking for is $6,945 for retro.
Okay, you wanna chime in, Ms. Cano, what you agree or disagree with?
I don't want to keep doing this. I want this to be over with. So if
Well, I'm trying to be fair and with the little limited information I have, and I know you don't wanna come back, so that's part of the
I
equation.
don't, I mean, and the biggest thing for me is that I'm doing this by myself and it's hard. And I just need help, ma'am. And so, I mean, if we got to stop this and not do any back pay so we can start this and we can move forward, I'm okay with that.
Ma'am, there's very few cases I get that people walk in and say, "He paid $12,000," or even if it was 10,000 because of the other small items. That hardly ever happens. They wait till court orders, they don't do that much, whatever. They don't know they should be doing something, you can't find them, whatever. So this man has done something. Now, did he do it precisely perfect? No. Did you come right away so you could get if she's what, 12 and 10 now, or I forgot what you said, 10?
10.
Then you could have had 10 years of child support if you brought the case as a baby, but you didn't. So you already gave up a bunch and you were doing a loan. I get that. But he did step up and has stepped in and has given at least $12,000. So you gotta give him some credit for that.
That's what I'm saying. Like, we just can get this done. Let's just stop all of this. No more back pay. Let's just move forward. I'm tired. I just want to get this done.
Ma'am, I can finish in the next 5 minutes one way or the other, but I can't believe that after all this, you're saying, now I want nothing. Let's just start scrap for fresh. But you can say that if you want, but I'm not trying to pressure you into anything. I'm trying to get the facts. I'm barely just now getting the facts. It looks like the facts are that if he paid this much and we had known and we had been there and done the math and he had known, then maybe he owes you $69.45. Mr. Garza, let me hear you respond. Why or why not? Shouldn't you be paying something, given that you didn't pay the whole 4 years, you didn't pay anywhere near for 10 years, but there's still maybe something owed here, even though you did pay up to $12,000. What's your position on $6,945?
Uh, I've done more than that I can account for right now as far as the 6,945 that's owed. So, I mean, if it's okay with her, I'm definitely. Can you guys hear me?
Yes.
Okay. If I mean, if that's what I'm okay with not paying any of it because I feel that I've been paying. It's not so the amount that's been transferred between accounts that's going to add to something as well. So I don't have a problem paying what I'm going to be paying going forward. One of the only reasons why I requested that we even revisit this is because the salary was skewed because of the amount of money that I made for that 2024 tax year. I started off the year working at a food trailer, so that money was included. Then I got a bonus at the end of December, which was a one-time thing that I didn't even expect. So that was included as well. So I was doing it on my phone just like I was this morning. And when I got to work, I transferred the documents over to my email on my computer, and I saw the salary that was used in the calculation. So it didn't jive with what I had. So that's the only reason why I requested that this be revisited all along. Um, so
But do you have any clue that your UFCU or whatever bank it was that you don't have the records for would equal anywhere near $7,000? That you an extra $7,000 that you paid?
Then the non-custodial parent takes the stand, and things tighten up. He admits payments, claims even more money passed through accounts he can't immediately document, explains bank limitations.
it would probably be another. I don't know. I don't know how much I don't even want to throw a number out there,
Well, she
but
threw
it.
out 500, and I don't know if you're gonna throw out 7,000 or not, but I'm trying to figure out if it's fair.
Yeah,
And
exactly. And I'm not going to throw out the full 6,900 either, but it was definitely more than 500. And I'm feel the same way that she does. I just want to move past this and get the right number, which is the number that we got based on the salary that I make, which was the 691. I'm fine with paying what I need to
okay,
pay.
you wanna go forward no matter what I do today? And you have the right of appeal anyway, if you really wanna appeal, if you think I got it wrong. You don't get to walk away and say, "I don't agree." You get to listen to what I say and either appeal me or not. That's what happens if I go for it.
Okay. And then I guess part of the appeal would be me showing up with those records from the
You
UFCU
could
that
you
should
could
prevent that.
you could possibly file for a new trial and go back in with better records and have better evidence for another judge and spend more time on this case, or you could
And
live
I
with it.
apologize. And I apologize. Had I known that we were going to go through this, I would have had those records ready as well. It wasn't
I
until
get
this.
that, but it doesn't help me right now. So are you willing to go forward right now or not? Because I haven't given you a continuance. Everybody says you want it over with. So I'm trying to see if you will or won't. And you have the right of appeal anyway, no matter what
No,
I do. So
I,
I give
I'd
you leave.
rather I'd rather not. I mean, honestly, I'm struggling as it is to make it in this world. So that extra 6,900 it's a little much for me. It is honestly.
Okay. And Ms. Gano, you're saying you want to get this over with no matter what?
Yes, ma'am.
And no matter what I do, whether you like it or not, you have the right of appeal too, and you want to get over with?
Yes, ma'am.
Ms. Nichols, you said you want to get it over with. You haven't heard from Mr. Garza and his records issue. You know, and I don't blame anybody because, yeah, you're in court. However, maybe you should think about what the issues are. You were here last time with those same issues. And if I don't even know what happened on retroactive or not, whether you should have known you had to bring this stuff or be prepared for it or not. But I'm not going to
Initially,
blame you for it, Ms. Garcia. You don't know. You're not a lawyer. Yeah, you found out kind of today how much was being asked for.
initially it was agreed that there was not going to be no back pay, which is why I didn't have my
Oh,
today. And then today, after we did the salary adjustment, it was like, okay, no, we want to do back pay. So that's why I wasn't prepared with the information I needed to have. I got what I could within that first, until you jumped on, and I emailed that, but the rest of it, after calling the bank, I couldn't.
okay. And Ms. Nichols, your position on whether this should be final or not?
Yes, this should be finalized.
Okay. Then, and any further evidence or to present, Ms. Nichols, or closing? I don't think you do. You already gave me the agreed parts, including the surname change, and it's just solely on the issue of retroactive. I'm not gonna beat a dead horse by having you summarize everything again.
No, but let me just quickly just get on the record that Mr. Garza and Ms. Gano actually agree to what I stated to the court earlier.
Okay. Didn't you do that already? No, you didn't.
I don't remember. I don't know that I did.
No, I don't think you did. It went straight to retroactive. So yeah, get that on the record for me.
Okay, Mr. Garza, you
Yes,
heard
ma'am.
you heard all the agreements that I told Judge Madrigal we made. Are you still in agreement with those things?
Am I in agreement with what we agreed on earlier?
Yes.
That you're the dad, that the surname changed, that the visitation is standard, that you're gonna communicate by app close, that your child support is $691, your medical support is $235, and your dental support is $5, all monthly starting April 1st. Do you agree to all that?
I do.
Okay. You want
And Ms. Kano, do you agree with that as well?
Yes, I do.
Okay. So, state rests. So just the state's recommendation is that based on the evidence we have, a retroactive judgment of $6,945 would be appropriate, and Mr. Garza should be ordered to pay that at $85 a month. So he would not pay that all at once. He would do a monthly payment of $85 if the court grants the retroactive judgment.
Okay. And you don't have to summarize this, Ghana, but has any of your position changed at all? Or maybe you should tell me what you want on retro or don't want on retro.
I honestly just want it to be over. So if we're
You
gonna
have a position. I'm gonna make a decision, but I want to know if you want retro or you don't want retro.
I
And
don't
then
want
you
to
get to live with me with whatever I say.
Yeah, no, if we can get it done today, then I don't want retro. That's what I said last time. And then he brought it back again. And that's why I asked for the retroactive, because it's like every time this keeps on happening, we have to come back again. And I'm here waiting and waiting and waiting. So that's the only reason I asked for it
It's
again.
gonna be over with. I am gonna do a final order. However, are you really giving on the record waiving any retroactive what he hasn't already given to you? You did that last time? Are you doing that this time or
So-
not?
So my question to you would be, if it's a final order, he can still go back and appeal, and then we'll be back here again, right? Like if he appeals it, then I won't start getting any help until we go back to court again.
No, my order would be a final order. It would still be good. It would still be put in the system. He still would need to pay it. And if I understand him, he's not going to appeal all the rest of it. He would only appeal the back pay if he didn't agree with my decision, if I ordered some. But I'm not even there yet. I'm asking you, are you asking me to order retroactive or not?
Yes, I am.
Okay. And Mr. Garza, you don't know what I'm gonna do. However, you already told me you want more time for more evidence. Is that still your position?
So I didn't understand. So is she wanting retro or not?
She said yes, but she doesn't know what the amount is, whether I'm gonna give her anything or all of it or none of it or part of it and you don't either. I'm still struggling with it, but I'll give you a decision in a few short minutes after you tell me your position on what I should do today, whether go for it as a final or you really want more time for more evidence. Because you can appeal that too, if necessary.
Uh, I mean, yeah, I'm still adamant as far as the retro amount, because I have been giving her money, and even before any of this came about, I was giving her. But yes, I am wanting to present that last piece of evidence to hopefully reduce the amount, because unfortunately, I'm just
You
like
remember I
everyone else.
told you, are you sure you don't want to reset? Or I asked you like an hour ago, how long have we been doing this? And you said, okay, no, let's go for it. Yeah, an hour and 2 minutes. Do you remember that?
I was okay with the amount monthly, but when it came to the retro,
The state breaks down retroactive child support year by year, minimum wage periods, CADE's improved income years, tax returns, and guideline calculations.
Well, I didn't know you didn't have documents until we actually got into the testimony, which means I think I asked you if you willing to go forward, and I think you said yes, instead of me just saying I want evidence now and doing that half an hour ago or 45 minutes ago.
yeah, I apologize for that. I just wasn't, again, I wasn't aware that any of the retro part of it, I wasn't ready for until this morning. So
Okay, this is what I think is fair, and this is what I'm gonna do. I don't wanna see y'all back here, and I don't wanna waste more time with you figuring out how much you paid or didn't pay through that UFCU account. It's possible you did a lot, it's possible you did hardly anything. I'm not gonna wait on it. I do things this way all the time on he said, she said, because people want me to go forward. And you kind of agree to go for it because you're here and we waited for you too after you dropped off. I'm gonna make this a final order, so I will approve all the agreements that were initially stated without me repeating any of them, other than the surname would be included in addition to the original agreements. And the surname changes Cano hyphen Garza. There's no non-disclosure to speak of, so there won't be any non-disclosure finding. And on the court costs, you know what? I'm gonna waive them for him. I'm not gonna order him to pay costs. He's done pretty good. I'm gonna reward that today. Okay, on the issue of retroactive support, I'm not gonna do 0, but I'm not gonna do $6,945 either. This man paid over 12,000 and possibly more through that UFCU account. Gosh, people are coming in for another hearing. What I'm gonna do is $2,000. I think it's fair that he pays something. There were several years that before he even started, I think, with interest on top of that, and that you've been getting it, and now you're gonna get more, for sure under a court order. And considering he had minimum wage for several of those first few years, I'm gonna do $2,000 in retroactive. And the reason, ma'am, it's not that I'm giving him necessarily credit, but the law says on retroactive that it's not mandatory, that even if you prove every single penny that, or that's what you want, that's a maximum you can request. But I can consider hardship. I am considering hardship that he was unemployed for a while, that he did the best he could while he could, and that there would be hardship to order another $7,000 or 10,000 or anything else on top of the 12 he's already paid. So based on hardship, I'll lower it to 2,000. I think that's fair. If you don't, Mr. Garza, you can appeal. I'm gonna ask the state to put the notice of appeal rights at the back of the order. And given that it's a 10-year-old and you haven't paid 10 years worth of child support, it's a small pittance here, but I'll do that. State have a recommendation on the payments for that?
Yes, $60 a month.
Okay, then I'll order that starting, if child support was due April 1st, I'm not gonna go backwards. Let's start July 1st, give him a chance to breathe and get things settled and appeal if he wants, but $60, July 1st, not June 1st.
Yeah, and the
Foreclosure rate. What?
okay, and the retroactive judgment should be as of March 30.
Correct. Wait, March has 31 days on
Does it? Let me see.
it? It's April that has 30, but I'm gonna look just to make sure.
Yeah, no, March. Yeah,
March
March
has
is
31 days.
March was 31, so yes.
As of March
March
31st, 2025, with child support starting April 1st. So that money that you paid, that she got,
The custodial parent speaks plainly. She's tired, overwhelmed, and just wants stability. The judge responds with rare honesty, acknowledging that many parents pay nothing until court forces them.
before March 1st, before April 1st, that'll be applied to this, I assume.
Okay.
Yep. And if you don't understand that, you can call them or hang. Do you have any questions, Mr. Garza? Do
I do not, Your Honor.
you have any questions, Ms. Khanum?
No, ma'am, I do not.
Wish you both luck. Thank you for being here and all the time it's taken. I hope you can live with it. If you can't, you go to another court. If you do all the right things within the right time periods, it'll be in paper. But from the day you get the order that's signed by me, first you're going to get a proposed order. You get to review it, see if there's any errors, sign off on that if you want to. If you don't sign off on it, because I'm approving your agreement and ruling on the contested issue, and I'm rendering the order, it becomes my order, so I can sign it without you, Mr. Garza, Ms. Cano. But I give you almost a week to review it, to sign it. I get it quicker. If you don't sign it by next, what's today? Thursday, by next Thursday, a week from today, the state will submit it without your signature and I'll sign it that way. I review it for accuracy. However, you all can do the same and sign it, or call the AG if you see any problems and work it out with them. But from the day you get the signed copy that's signed by me, Mr. Garza or Ms. Gano, you have the right to file a written notice of appeal within 3 business days. So whatever that day is, you don't count Saturday and Sunday, but it's 3 business days. And you, if you do that and you file it with the clerk and you give them copies of the de novo appeal to both parties, the AG and the other parent, then you call the district clerk and get a court date within 30 days. Then you can have your new day in court. If you miss any of that or you file late, your appeal rights are out the window. So I'm trying to tell you that. And if I'm not sure you totally understand it, but call the AG if you have any questions, Mr. Garza, and how that money is applied to what you're going to owe. And that'll be the order of the form. So start looking for the order anytime, probably after 5, maybe even tomorrow. But do check. That's priority homework, please. You're excused. Thank you, folks. Raise that child. Try to talk to each other and be a good role models. That's what's more important than anything else. And people do better when they know better is all I can say. So start fresh. Thank you, folks. Don't
This case shows what happens when parents delay court involvement, rely on informal payments, and hope things work themselves out. In the end, the court steps in, draws the line, and forces resolution. Not perfect, not painless, but final. And sometimes that's exactly what justice looks like.